I'll email you back. You'll get an electronic link on March 13th. In the email to you.
Yeah, you will send. That's it. Ready, Amy?
Okay, it looks like we're back.
All right, thank you, Amy. We have arisen from executive session, closed preliminary hearing. I will turn it over for 2 items for our vice chairman to take control.
Same thing?
Yep.
Gotta get the cases again. No, 31, 33.
30 and 33.
33. 4A30 and 4A33.
Yes. Say it again.
Mr. Chair, would it be helpful if I recommend some motions?
Just a minute.
Yep.
Okay. Marnie, can you recommend the motions that were read on item 30 and 33?
Absolutely. So we'll take them separately. The first is agenda item 4A30, DeBoer versus Hammond. Is there a motion to accept the recommendation of the hearing officer and general counsel to find that the complaint was filed on justifiable grounds as to section 9-8.10A11 of the election code, section 9-11A12 of the election code, and section 9-11A13 of the election code. And that those should proceed to public hearing with a scope limited to October 1st, 2023 through September 30th, 2025. The remainder of the complaint was not filed on justifiable grounds and should be dismissed.
We have a motion and a second on those.
So moved.
Second.
Amy, roll call?
Ms. Mallory-Croft,
Yes.
Ms. Cray,
No.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin.
Yes.
Motion passes.
General counsel, item 33, please.
Fold versus Citizens for Judge Chris Pratt. I would recommend a motion to find that the complaint was filed on justifiable grounds as to section 10B and section 10C of the election code, and that those matters be referred back to the Division of Campaign Disclosure to assess any appropriate penalties. That the claim under section 9-10E was not filed on justifiable grounds. And finally, that the allegation under the Illinois Code of Judicial Conduct should be dismissed for lack of jurisdiction.
I have a motion and a second on the general counsel's recommendation.
So moved.
Second.
All those in favor, Amy,
Roll call.
roll call.
Ms. Mallory-Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin.
Yes.
Motion passes.
All right,
Here.
Marnie, 4A31 Morel versus Jet.
Okay, is there a motion to find that the allegation under section 9-3 of the election code relating to an incomplete statement of organization was filed on justifiable grounds, but no further action needs to be taken by the board because the error in the statement of organization has already been remedied? As to the complaint under section 9-3, that section was violated by raising and spending money in preceding months before filing that statement. That allegation was not filed on justifiable grounds and should be dismissed. And finally, that the section 9-10E allegation of an independent expenditure was not filed on justifiable grounds and should be dismissed. And finally, that the hearing officer's report should be corrected to reference section 9-1.15 rather than section 9-1/15.
Do we have a motion to that?
So moved.
If we. It's been moved by member
Second.
McCrory, seconded by member Ballard Croft. Roll calling.
Ms. Ballard Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right, now we have 4A32, Cassini versus Hines.
In this case, the recommendation of the hearing officer should be adopted, which is to find that the complaint under section 9-9.15 of the election code for failure to include attribution of source language was filed on justifiable grounds. That no public hearing is necessary, however, because instead the committee should be ordered to refrain from, or excuse me, to include section 9-9.5 of the election code attribution of source language in its future communications. And if it does not, it would subject the committee to a civil penalty of up to $5,000 for violating the order.
All right, thank you, Marnie. Do I have a motion?
So moved.
Second? It's been moved by member Ballard Croft, second by member Genovese.
Senator, whoa.
Roll calling.
Ms. Ballard Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right, 4A34, Marnie.
Hagerman versus Betsy. Complainant Hagerman did not appear, so it's my understanding that the board is interested in dismissing for want of prosecution.
Do I have a motion?
So moved.
A second.
Second.
It's been moved by Corey, yeah, and seconded by member Craig. Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes.
Motion passes.
All right. I know, we have a party next door. 4AB,
4AB is consideration of a CLAVA complaint, Ken Del Senor versus Kane County Clerk John Cunningham, 25 CLAVA 1. Our Deputy General Counsel, Jordan Amber, has handled this matter all by herself, and she is going to introduce this matter to you.
all right, Jordan, it's all yours.
Jordan will tell you, the complainant decided not to come. Guys.
Good afternoon. Am I coming through okay, Chicago?
Yes.
Yes,
Wonderful.
Be advised, it sounds like there's a farmer's market behind us right now.
Yes,
Very hard to hear.
so speak up, please.
I will do my best, but as always, ready, willing, and able to accept criticism. So, This matter, a HAVA complaint, was received by the board on December 19th, 2025. A copy of the complaint is included beginning on page 168 of your packet. The general counsel assigned this matter to me for review and recommendation under Part 150 of the administrative rules. In this complaint made under the Help America Vote Act, the complainant, Ken Del, D-E-L, Signore, S-I-G-N-O-R-E, alleges that the respondent, the Kane County Clerk John Cunningham, in his official capacity, is violating one section of the Help America Vote Act and 3 sections of the Election Code, all of which through Kane County's use of 3 pieces of machinery. The machinery identified is a combination of an envelope scanner, an envelope opener and sorter used for processing vote by mail ballots, the envelopes used for processing vote by mail envelopes, and a high-speed ballot scanner that then scans and tabulates the ballots. The complaint alleges that these machines, when used in combination, create first a scanned image of the information that's contained on the vote by mail ballot envelope, and then on the separate scanner and tabulator, scans of the image of the marked ballot. These 2 things, when used in combination, complainant alleges, has the potential to create a 1-to-1 correlation between a voter and their marked ballot. The complainant alleges that this process violates specifically 52 USC 21081 HAVA, and then 3 provisions of the Illinois Election Code, Section 17-16, Section 19-8, and Section 24A-10. All of these sections relate to ballot secrecy. Excuse me. As my written report notes, complaints made under HAVA are governed by Part 150 of our administrative rules. The first substantive analysis that occurs under Part 150 is Section 150.30, titled the Preliminary Review of the Complaint. This section requires 3 elements of a HAVA complaint in order for that complaint to be valid. First, it must allege a violation under Title III of HAVA. Second, the complaint must pertain to a federal election. And 3, the complaint must state sufficient facts to constitute a cause of action under HAVA for which the board can grant appropriate relief. While the complaint here, in my opinion, satisfies the first 2 elements, I recommend finding that the complaint fails to state sufficient facts to constitute a cause of action under the cited provision of HAVA and under the 3 cited sections of the Election Code. First, with regard to the cited section of HAVA, it is my opinion and recommendation that the board find that the complaint fails to allege facts, circumstances, or processes governed by 52 USC 21081 subsection A1C that are violated by Kane County's processes identified in the complaint. This section of HAVA states in its entirety, quote, voting systems shall ensure that any notification required under this paragraph preserves the privacy of the voter and the confidentiality of the ballot. The notifications referenced in this subsection relate to overvote notifications that voting systems have to tell the voter. The processes and the procedures alleged in the complaint do not touch on voter notifications at all. Excuse me. As an alternative to dismissing a complaint on this basis, however, Section 150.30 of the Administrative Code does afford the board with the ability to refer a complaint to a division of the board, an election authority, or law enforcement for investigation. However, I recommend that the board dismiss the complaint as it fails to allege facts and circumstances that state a violation of the cited provisions of Illinois' election code as well as federal law. As previously discussed, the machinery identified in the complaint handle and process vote by mail envelopes, and they tabulate ballots. Two of the cited sections of Illinois Election Code 17-16 and 24A-10 do not touch on vote by mail processing. Section 17-16 details how defective and spoiled ballots are to be treated and processed during in-person voting. And Section 24A-10 details how jurisdictions are to receive, store, transport, and tally votes cast. All of these procedures are outside of the scope of processing, sorting, and tallying vote by mail ballots. Therefore, I recommend that no action or referrals take place with regard to sections 17-16 and 24A-10 of the election code. This leaves us with one final section of the election code, and that's section 19-8. This section of the code provides the method by which vote by mail ballots are to be processed, voters verified, and vote by mail ballots tabulated. It also provides the procedures for rejecting a vote by mail ballot. But here it is my opinion that the complaint is devoid of specific facts that establish a violation of these procedures as used by Kane County. Additionally, in my opinion, no reasonable inference from the processes alleged in the complaint can rise to a violation of the procedures detailed by Section 19-8 of the Election Code. At best, the one-to-one comparison alleged in the complaint between the envelope processing machines and the ballot tabulation machines is speculative, because the complaint does not identify any detailed actions which occur circumstance that complainant's speculated voter ballot identification would or could actually occur. The complainant does not identify any processes used by Kane County where the scanned vote by mail envelope information is actually or reasonably viewed simultaneously with the scanned ballot images as they are processed through the high-speed tabulator. Therefore, I do not recommend that the SBE take formal action or find a violation here. However, I do recommend that a member of the Division of Voting and Registration Systems testing team connect with Kane County to discuss potential procedural enhancements that could eliminate any perceived risk here. As the complaint itself identifies, simply shuffling the ballots could accomplish this, or there are other procedural defects or other procedural enhancements that could entirely eliminate this perceived speculative one-to-one comparison. So for those reasons, I recommend that this complaint be dismissed under section 150.30 of our administrative rules, and that no further action be taken with regard to the alleged violations of our election code. The complainant, as Marnie noted, the complainant was provided notice of this matter, and within that notice was given the opportunity to appear. But this morning, he emailed us and asked that a statement of his be read into the record. Of course, we're not obligated to do so, but I'm happy to do so if the board so wishes.
Yes, read, please.
Okay. The complainant said, quote, "The general counsel did not reply to my allegations, but rather to some scenario that was not alleged. Any reasonable juror can see that Kane County cannot guarantee that the ballot information is secure, and therefore a bad actor could exfiltrate the data and de-anonymize the ballot. I thank the ILSBOE for their time. Please issue a final ruling in this matter so that the process can advance to a courtroom. Thanks. Ken Del Signore." End quote.
Thank you. Do I have a motion?
Question first?
Yes. Question, member Brett?
And just a
Yeah.
procedural question, your recommended course of action, Jordan, is dismiss the complaint and then informally have a member of board staff investigate the veracity of some of the allegations. Is there any,
No,
could we flip that and hold off on a decision today and then get the feedback from board staff?
while that is certainly an option, Member Brett, I do want to clarify, my recommendation is not that board staff conduct any investigation, but simply that they reach out to Kane County and discuss what their process is and identify any possible scenarios that they could, where they could alter the processes to avoid even the perception of a one-to-one comparison occurring.
If I may.
Barney?
So there is no potential violation of the election code. All there is here is something that could look to the public to be concerning. And we would like to help Kane County in improving their transparency and making things look fair. By giving them some suggestions of how to do so. We don't think they're violating the election code. We just want to give them some pointers to maintain a free and fair election.
Member Brett? All right, do I have a motion?
I make
Say
a
that
motion
again.
to accept the recommendation of Deputy General Counsel.
Is there a second?
Second.
It's been moved by member McCrory and seconded by member Turbin to accept the recommendation of our deputy chief counsel. Roll calling.
Ms. Pellegrom,
Yes.
Ms. Gray,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes,
Motion passed.
Thank you.
thank you, Amy. Thank you, Jordan.
Thank you.
All right, now,
My final item.
yes,
I yet again, delegated this to someone else, so you don't have to hear me talk much longer. This is agenda item 4C. It is the proposed rules, part 208, constitutional amendments and statewide questions of public policy. Our legislative analyst, and attorney, Heidi Boyer, Poyer, is going to, address the public comments that were filed. As well as talk about the language that was filed with JCAR and discuss any next moves that the board is inclined to take. So thank you, Heidi.
all right, Heidi?
Good afternoon. Can you all hear me all right?
Yes. Yes.
Yes.
Thank you. This is my first time presenting to the board and I'm happy to be here. I'm going to discuss the Part 208 rulemaking that was approved for filing by the board with JCAR during the board's November 18th, 2025 meeting. So these rules set forth a process for disposing of proposed constitutional amendments and proposed statewide advisory questions that were submitted with less than the required number of signatures. At the November meeting, it was decided that once the public comment period for this rulemaking concluded, the legal division would supply any received comments to the board, and board staff, that's me, would not proceed with any rulemaking process until the board authorizes me to do that. The public comments in their entirety are in the board packet beginning on page 178. Right after those comments is the text of the rules themselves. I'm going to give a very short summary of the comments and provide the legal division's recommendation as the best way to address them. The board received 2 public comments. One was from John Fogarty and one was from William J. Cadigan and Michael Dorf, who represent Fair Maps, Illinois. Both of these comments came in on January 19th, 2026. In short, the very short summary is that the public comments are substantively identical to concerns and questions that have previously been considered by the board. Because of that, it is the recommendation that the board move forward with the rulemaking in its current form. If JCAR does request specific substantive changes, the board does have the opportunity to consider those at its March or April meeting, depending on when the feedback comes in, or if it comes in. If there are any specific questions about any of the public comments, I am prepared and happy to talk about that. Thank you.
Thank you. Questions from Heidi?
I just have a question, Member Chair.
Member Craig?
I brought these concerns up in November. Both of these comments reiterate my comments at that time. What is the opposition to taking these two, to taking the statutory authority question out and taking the pagination out? What is the opposition that our legal department has, and then proceeding with the rule?
Are you talking about Mr. Fogarty's comments, or was there
Talk about Fogarty's.
I think so. Because I didn't, I'm not sure if I caught the specific recommendation, any specific recommendations in the Fair Maps comments. Mr. Fogarty had two main things. One of them was he suggested changes to the notice provisions. The specific concern, as I understood it, is that in conducting a signature count using the board's current processes and technology, and then by making those results public, it's impermissibly providing a material advantage to an opponent. However, if a petition does not have enough signatures on its face, the end result is that the petition will not be certified, regardless of whether or not we tell the opponent or about the staff count or not. But on the other hand, if there is an opponent, we cannot provide notice of potentially dispositive proceedings to one party without also providing the same notice to the other party. So the language in 208 is reflecting constitutional due process requirements.
But it does give you a definition for proponent. It does not for opponent. How do we know who the opponents are? How do we know that they all get notified? How do we notice that this gets out to everybody? The proponents are listed as they turn in the petitions. The opponents are not listed anywhere.
I believe that the legal department's consensus is that the language as it's drafted reflects constitutional due process concerns and conforms with the statutory requirements.
Okay, you really don't have an answer for me there. As I said, I brought these questions up back in November also. What is your rationale for continuing on and not taking these two provisions out? Why are you so gung-ho on these two, that these two things have to be in, these two items have to be in this rule?
Well, I believe that they were discussed at the last meeting, and there hasn't been any new information or legal arguments that have been put forward that would cause me to go, whoa, we better fix that. I think the board was comfortable enough to move forward last time, and there hasn't been enough change to change that.
So you are confident going forward that when we get sued, that we don't have the statutory authority to do this, you could win this in a court case?
Well, I'm saying that I'm confident that we could go to JCAR and see what JCAR says and see what kind of feedback we get from them.
I'm done, Mr. Chair.
Okay, thank you, Member Craig. Member McCrory.
And I'm gonna take this one step further. I do, and it could be my ignorance, but I'm a pragmatic person. If we do not have a definition of who an opponent is, how are we providing, and I understand the due process arguments 100%. But if we don't have a definition of who an opponent is, how are we providing notice to that opponent? How are they identified? Are they identified as a general, publication in a newspaper, or how are we identifying and notifying those opponents?
Article 28 generally, Member McCrory,
Yes.
defines and identifies a process by which opponents to a filed public question, be it a or constitutional amendment, it identifies a process by which opponents to that public question register and file with the state board. So it is at that time that those individuals are identified. Article 28, I believe, similarly identifies a process by which proponents are also identified.
Thank you.
But furthermore, I'm sorry, may I ask one more question, please?
Yes.
Furthermore, in 2812, it says there is no provision for the opponents to make a counter presentation. So they don't have due process.
That's an interesting observation. I am not sure that there is a situation that wouldn't exist in which opponents would have some type of strategic reason to argue that the statistical analysis should occur. The rules say that either party can argue that the statistical analysis should proceed. But that would be the scope of the argument, is whether to proceed with the statistical analysis or whether to let the staff count stand.
To rebut.
To rebut that staff count, yeah.
I believe the matter before that is contemplated here is to rebut the staff count specifically. So we're looking at the documents that are presented through this process, simply identify how many signatures have been filed with the petition and the number of signatures that are on each page. And the scope then of inquiry for proponents and opponents alike before the board under this process would be limited to rebutting that staff count and the number of signatures that have been identified through that. So then logically extending that out, if the determination of the board through this process is that there are too few signatures to proceed, it is unlikely then that an opponent would, to a petition, would be opposed to not certifying the ballot or the question to the ballot because too few signatures had been filed.
You're still opening the door for opponents. You're the one using that terminology, and therefore you're opening the door, and yet there's no provision for them to make a counter presentation.
And again, it's simply our understanding that these.
I understand where you're saying it's unlikely, but I'm saying it's likely, and you're denying someone due process because we're opening this door.
Who are we denying due process to? The opponents now? I'm just trying to follow.
All right, member Victoria has a question. Oh, member Brett.
I thought that the submissions from public comment by both Mr. Fogarty and Mr. Cadigan and Mr. Dorff were very, very thoughtful and respectful. I believe that our goal in this rule is that we want to enhance the efficiency of the Board of Elections and make it easier for board staff to dispose of constitutional amendment ballot initiatives that on their face do not meet a certain threshold to save everyone time. I believe that Mr. Cadigan, Mr. Dorff, and Mr. Fogarty presented a good faith argument, and I was persuaded that there are concerns about statutory authority. And I also believe I was persuaded by the argument that Mr. Fogarty presented about opponents getting an unfair advantage from it. So my question for council is, what would be the rationale for not adopting Mr. Fogarty's recommendations, which I think is a consensus course of action that allows us to achieve our ultimate goal, comply with our statutory authority, and also not run the risk of providing an unfair advantage and sticking our thumb on the scale when it comes to constitutional amendments?
So the constitutional authority, the statutory authority question. So Article 28, if you construe that as requiring a statistical analysis for every filing, that would create an absurd result. We all agree on that, of allocating state resources to conduct statistical analyses on petitions that cannot be certified to the ballot because they lack the number of signatures that they need. So by setting forth this statistical analysis paradigm, the General Assembly is expressing an intent that petitions that don't have enough signatures should not be certified to the ballot, regardless of who's the parties or whether they're opponents or not. They're kind of giving the state board some authority to dispose of these in a little bit of a different process than, you know, candidate petitions. And so that statutory authority, while it's a little bit quiet on how that situation should play out, these rules are within that paradigm, because at the same time, the result is going to be the same. If we count the signatures and there aren't enough at this stage, then we just don't go to the next stage. But if we count the signatures and there are enough, then we just proceed as if any other petition would be. We'd go forward with the statistical analysis.
And moreover, Member Brett, to your question, it is our understanding that the substance of both of the comments that were received from Mr. Fogarty, Mr. Dorff, and Mr. Cadigan were all considered by the board at the time that the board authorized us to file the.
No, they weren't. No, we received those comments. We opened up public comment section or public comment ability after the November meeting. So those were not considered by the board when we said, go ahead and let JCAR have a look at them. And then get to the public, and then we would come back and we would review them. So that's not correct.
Well, I think the Member Frey had expressed concerns, so I think those were the concerns that they've been talked about.
Yes.
It sounded, yeah, I believe that they were fleshed out a bit more. The comments did flesh out some of the ins and outs of the legal questions. But they are questions that we did consider in drafting this and in presenting it to the board.
Based on the written submissions.
Member Brett.
Thank you. This is just me speculating, but based on the written submissions and based on the comments that we've had in these debates today, and then some of the questions in November, I suspect that if we revise the amendment along the lines of the recommendations of Mr. Fogarty, I suspect that we would have consensus on this board to move forward with the regulation, with the proposed regulation.
And Mr. Fogarty's in the room, so I'd like him to step up. What he's at.
Oh my God.
Is that appropriate?
It's up to the chair.
Mr. Fogarty, would you be brief, please?
Sure,
If you're talking about Mr. Fogarty's letter, but he's sitting right here.
I'm sitting right here. Thank you.
I don't know if that's on.
So this is on. Great, thank you. Thank you very much. Thank you very much, and I will be brief. As has been noted, we support the idea of you quickly disposing of an amendment that is filed that doesn't have enough signatures on its face. What I see this rule doing, though, is taking an amendment that does have enough signatures on its face. You providing a count and you provide a pagination anomaly that can be used in an objection to a proposed amendment. The timing of your signature counting is well in advance of when an opponent of an amendment must file an objection. All of that information can be used in an objection to invalidate the amendment. And so I don't believe that that is a fair sort of use of the resources of the agency, and I expressed as much. More to the point, though, to the legal point, is this statistical analysis, yes, exists so that you can determine, are there enough valid signatures? The statistical analysis as set forth in statute is a process between the proponents, the people who file the amendment, and the board. It is those two parties. There is not a place in statute where it says, oh, if you're an opponent, you can go ahead and make an argument as to why this statistical analysis is incorrect. There's no place for opponents. The place for opponents is an objection, and it's a well-worn path, and that's just how that works. And so those are my comments, and you know, respectfully, I did submit that just with a couple of tweaks, I think that this could be just fine. And at the end of the day, you know, this isn't earth-shattering stuff, but I do believe that it is a problem. And if I'm representing a proponent and file an amendment, and my opponents get to come in and argue at the statistical analysis stage, and then at the objection stage, when it's not authorized in statute, I think that's inappropriate. And so that's it. Thanks.
Madam Chair, I have a question for Mr. Fogarty.
Member Watson?
What about this pagination business?
I'm glad you asked, Member Watson.
Yeah, can you speak up so I can hear you?
Absolutely, yes. So pagination errors are handled differently legally for advisory referenda as they are for proposed constitutional amendments when you're determining how many signatures should be considered to be good.
They're handled differently, you say?
Yes, yes, they are. Yes, they are.
Oh, okay.
So that's why I think that, you know, going so far as identifying pagination anomalies in a public document is not the direction you should go.
Yeah, right. You're right. Mm-hmm. Okay.
Member McCrory?
I just have one more question. Other than the due process argument with respect to opponents, is there another argument that can be made as to why they should be notified at this initial stage? If there is found to be an invalid petition.
To this end, we simply intended that these draft rules encompass all entities who had been identified through process or through Article 28 to be advised of any juncture where there was a possibility of the board engaging in a dispositive decision on the matter, whether that is to inform them that a petition was not going to be certified as a result of filing too few signatures on this staff count, or whether a petition would be proceeding through to the statistical analysis as provided. And again, I simply want to inform the board that we don't have an opposition to proceeding or to not proceeding with the content and the substance of these rules. We simply want to ensure that we are following the will of the entire board and allowing it to go through the administrative process as contemplated by JCAR, which is a long way of saying, we will do what you want us to do on this, but we also want to ensure that the ultimate goal of having a determination of what to do when we receive these facially deficient and facially insufficient statewide questions are received.
And thank you for the work that you guys put into this. I think you feel like you're sitting on a hot seat right now, but it's more of a devil's advocate thing than it is that we're questioning, you know, the work you put into it or the thought you put into it. So, to my mind, there's a very low risk of a lack of due process or a claim for due process from an opponent in that scenario. So those are just my thoughts. I think Vice Chair Turvin has a question.
Member Turvin?
Thank you very much. I think we need buttons. What I would like to say is this, I think everybody's going in the direction, but I think that we didn't hear maybe what Heidi said to begin with. And that is what she's looking to do was talk to JCAR to see what their opinions were in those two items and to see if that would be something to caution from and bring it back to us to let us look at it and tell us what you found out when you and Brian or whoever you go with, all right, can do that because this has been on our plate for a long time in November and it's been trying to get through that, right? And I thought that Mr. Fogarty did a good job of giving us ideas and suggestions in his letters. I didn't know too quick on the other one, but I do know that that was the one I saw that said, here are some ideas to make it go forward. Heidi's idea is to make it go forward, to understand that we put it out for notice, and this is what we put out for the notice. These are the things that were brought to us. Do you at JCAR see any error of caution here that we should be aware of? So that way we could get to that point. So hopefully we could get this off of our plate and off to the next step.
Now, the other thing is, just for full disclosure and just so you guys have all of the information that you need, if we wait on these rules longer, that just means that they might not be in effect for this cycle. And so if we just keep going, if we, just depending on what pace you want to go at, that will affect whether we have them up and running for this cycle or whether they go for the next one for, the petition filing season.
Well, I have one quick question. The whole point of this rule, as I understand it, is to deal with insufficient petition, insufficient signatures. Not one that has enough signatures. And that's I don't understand why we don't go forward because it's specifically to deal with insufficient signatures.
Well, Madam Chair, I'm concerned about the pagination myself, as well as the other things that Mr.
All right,
Fogarty was
hang on
talking
just
about.
a second. Thank you, Member Watson.
So if the lawyers in Springfield can tell me what you're sending to JCAR with respect to the pagination issue.
Absolutely, Member Watson. If you will bear with me just one moment, I want to read from the actual text of the rules and not rely on my relatively overtired brain. Subsection C of the rules states as follows, of the proposed rules. Within 3 business days of completion of the signature count, the SBE will issue a notice of signature count to proponents and opponents as defined by section 28-9 of the code. Notice of the signature count will include 1, the number of pages filed within the petition, 2, any pagination anomalies identified by the staff's count, 3, the number of signatures contained on each petition page, and 4, the total number of signatures filed with the petition. As for better or worse, and I may not want to admit this here, the author of these 4 subparts, the intention for number 2, any pagination anomalies, was simply to advise and put the filers on notice of showing our work, right? If we're going to say that you have filed 100,000 signatures on page 1, so the intention is that the report shows page 1, 10 signatures. If there are 2 page 1s, that second page would simply be identified as 1.1. And so that is in and of itself a pagination anomaly. However, I understand, as has been absolutely identified through this conversation and through this discussion, that the word anomaly may not be ideal.
Right.
Hurt. However,
all right, just a second, George, Member Brett.
I would like to make a recommendation. I would feel comfortable.
Speak up, Mr. Brett. Please
Yes,
speak up.
I would like to make a recommendation, and it can come as a motion if necessary, but I would request that board staff rewrite the rules based on the two recommendations that occur on page 180 of our board packet, which is the end of the public comments submitted by Mr. Fogarty, and submit to JCAR as amended, in the public comment, removing reference to the pagination of anomalies, and also removing all references to opponents.
All
If that is
references
the
to what?
motion,
Is it appropriate for a motion?
So if I may, I think what we ought to be doing is we can decide if we want an alternative draft drafted. But I want you all to review that alternative draft before we send it to JCAR. And that's the way we're gonna.
Yes,
Okay, so.
yeah,
That's option 1 is to move forward with the rule as drafted. Option number 2 is to draft an alternative. And then we can come back and look at both
Yes.
and decide which one we like better.
Yeah, I'm not inclined to make any decisions until I have all the information.
Bernadette?
I was going to say that I think it's a good plan to have us review the comments and any suggested changes, because parts of these rules as drafted were just memorializing and making more transparent the process that we have already used on 3 previous constitutional amendment petitions that were just general information. They come in on a Mack truck, like a semi, they're huge. They run the entire length of that room that you're in down Springfield. Humans put them together, therefore there are usually page errors. But we as staff do look at every single page as part of our first initial process, is dismantle a petition. Look at every page, log every page as numbered, or if it is missing a number, misnumbered, there's 2 page 31s, 31.31 and 31.1. We will mark in a program every signature line and the line it's on, so this is the entire process that needs to be done before we hit the button and then select the signatures that we save. So essentially what we are saying is to come to even just an initial signature count. This is the process staff does. It is a specific signature line that is in a report. In order for us to rely on that signature count, we would need to be able to, as Jordan said, prove our work, show that we looked at every single page, we logged it as such with different, whether we call them anomalies, discrepancies, errors, what have you. But that will be logged in a report. I think here when initially drafted, the reason we said that sort of readout with all of that pertinent information that proves our work would be available to opponents and opponents is because the constitutional amendment petitions, the General Assembly wrote in that opponents are allowed to file. So obviously there's some part of the process and this information that they are entitled to in a different way than just the regular objection process with candidate petitions. And therefore, if we are relying on this number to either say, yes, we move forward with a random sample, or no, we don't move forward, that those registered entities, both the opponent and proponent, through this rule, have clarity of what our process looks, have the transparency of a report, know what we based our numbers on. So I think when we were saying to the board previously, let's submit it to JCAR, let's have JCAR, who a lot of times are the ones that determine what our authority actually is and when to include possible opponents in the process. We'll let them take the public comments, read through it, let them tell us what they would like us to change. But if you would like to see another version, or at least have a recommended another version at the next meeting, I think it's at this point appropriate for staff to confer, be able to at least present options to you if we would like to move forward with a different version that JCAR would have found.
I have a question.
When are we getting JCAR's response?
Mrs., I can't hear. Bernadette kept going in and out.
When are we getting JCAR's response?
I'm sorry, can you repeat that?
And we got a response, you submitted this language to JCOM, correct?
So we did a first notice, a public notice period, but we have not resubmitted to JCAR. However, it's my understanding that if Heidi wanted, she could reach out to JCAR and say, hey, this is what we're considering, what do you think?
Well, you said.
I believe Heidi would be probably the best person to speak on that process, if
Yeah,
we
you're
may.
right, you're right.
So,
Way to go.
so there are two notice periods before JCOM. The first notice period is a public comment period. That is the period that is just concluded. And so we've gathered the public comment and we've given them to you. And so if you decide today that you want to move forward with the process, there's a second notice period that lasts 45 days. So so what happens practically is, from a practical standpoint, is we notice it up to JCAR and then they place it on their next meeting agenda. And then JCAR staff reaches out to me if any of the members have any issues ahead of that time. And then we're able to address any, usually it's very small potatoes, non-substantive matters where, they just like things formatted a different way. But if there are any serious concerns, then we can make changes before that meeting, if that's possible. If the suggested changes happen to be exactly the same as the ones Mr. Fogarty put forward, then, maybe you're comfortable with us just doing that. Or JCAR and the board can agree to extend that notice period an additional 45 days, and then that would give you more time to negotiate a different rulemaking.
Does anybody have a suggestion? Motion?
Well, I thought Mr. Rutt put forth a motion and I seconded it.
I'm not in a position to roll a motion. I don't
He had a
know.
suggestion. He had a suggestion. He didn't make a motion.
motion.
I don't think that he said a motion. I think it was a suggestion or a recommendation is what I thought he said when. Talk about brother, remember Brett?
That is correct. It was a suggestion, not a motion.
Okay.
I would feel more comfortable seeing a draft that incorporates the suggestions for public comment before moving further.
And just to clarify, member Brett, when you say moving forward, you mean filing for second notice with JCAR?
That is correct.
Thank you very much.
Then I think we would need that in the form of a motion. No.
I missed exactly what happened just now.
Okay,
So we are filing a second notice, we are not filing a second notice, we're coming up with an alternative and we can look at those alternatives. That's what we wanna do?
Yes.
Okay, well, we don't have to vote on anything.
Correct.
Cause we're just gonna come back and talk about it again with some more alternatives and some more ideas and we'll see what people like.
Good.
Jordan, thank you.
yes. All right, thank you, guys. Marnie?
I am done, thank you.
Bless you. All right, report of the executive director, Bernadette.
Okay, can everybody do me?
No, I don't think so.
No, your mic is non-existent.
Well, I think might be because people are.
I have some noise down here, guys, sorry.
Is this one better?
Yes. You can forget it.
Yes, okay. Okay, well, I will move on with my report, which is mostly informational right now. The first item, it is for the upcoming March primary. It is just a report on the UOCAVA balloting deadline. So all the election authorities throughout the state did meet the 45-day deadline to transmit UOCAVA ballots to military and overseas voters. This was really, it's always really important. The Department of Justice does require us to submit a survey and essentially certify that we have done this on time. If we do not, we can and have in the past been under a consent decree, so we haven't had to do that for several election cycles now. But it was especially hard for the election authorities because of the judicial reviews that were ongoing, especially for a statewide candidate. Yet they still got them all out. The survey was submitted to the DOJ and the response was thank you and nothing else. So we will put this one kind of in the books and consider it successful without balloting. Abby Beatty in the Springfield office and Brent Davis did a lot of education on and reminders to the election authorities to meet this. They assisted with a lot of questions about what would fulfill the requirements as well. So wanted just to thank them because they made sure that all the election authorities had a resource and were on track and got those ballots out. So that's positive for my report. I also have
May I ask a question real quick,
yes.
please? Speaking about getting their ballots out, I know in the 11th congressional, the candidate won in the courts and she is now back on. And I know that in Champaign County, there was a misspelling of a name and the clerk has said he is not going to change the ballots and correct the spelling. Do we have any precedent, anything to get a note out there to those county clerks and say, hey, you guys do all you can to get these things correct? I just feel like, I don't know, maybe people don't care anymore. I'm reading news article after news article and ballots are wrong. I know we can't give formal opinions, but is there anything we can send out that says, hey, you guys, this stuff needs your attention?
I'll generally note, before I pass to Marnie as to what our authorities are, but I'll note that whenever we submit the amended certifications, we always make it clear that the statutory requirement is to then update the ballot. That being said, when these cases happen this late in the cycle, often election authorities seem to be weighing what's going to make sense in a resource way, whether it's financial or personnel, to be able to do those updates. So we reinforce throughout the period before early voting that these updated certifications are going to come, and the requirement is that you do update those. Typically, if there's questions or we hear that a jurisdiction did not, we will reach out. Marnie will have a conversation with the state's attorney, but I will also now hand it over to Marnie as to exactly how far those conversations can go.
Okay, so I'll address the Champaign County issue first. The Champaign County clerk is fixing the incorrect spelling on the ballot going forward for early voting and for actual regular voting election day. However, last I heard, which was last week, they were declining to remail out vote by mail ballots. I spoke with the county clerk. I gave them all of the precedents that I was aware of. No, excuse me, not with the clerk. I apologize, with the state's attorney. I gave them all the precedent that I was aware of, and I've done all I can. At this point, they are the legal advisor, and they are the ones who will make the decision as to whether or not the law requires them to reprint and remail the vote by mail ballots. I directed them to the statutory provisions. And that is, in my opinion, all that I can do without providing legal advice. Also know that the representative for that candidate is also in communication with the Champaign County State's Attorney's Office. And so that is being handled as well by the candidates. Now, on the Tedora Brown issue, my understanding is she was on some ballots and not on other ballots. At this point, my understanding is that everyone is putting her back on the ballot that did not. And if you get information that that is not the case, then I want you to please reach out to me immediately.
Marnie, thank you. That makes me feel better knowing that you've talked to the state's attorney. I just want to make sure on our end, we're doing all we can. Thank you.
Yeah, just to supplement, I believe in the Tedora Brown situation, DuPage County had begun early voting and she was not on, so they halted it, fixed the ballots and then resumed. And I believe that they're also reissuing any vote by mail ballots. And then Cook County had not yet begun early voting, so they were also able to update and her name will be on there for early voting. Okay, any other questions?
Any other? All right, continue, Brett.
All right, thank you. The next item's informational. It's just the election judge training school schedule so that you can see the jurisdictions that we are providing election judge training in and the staff that are assigned to it. Just a general reminder that all election judges must undergo a training ahead of each election, whether they have the SBE come and do it or they do it themselves is really up to the jurisdiction. But if requested, we will go, we send our staff there and conduct the trainings in conjunction with the election authority. The next item is consideration of the revised FY 26 board meeting schedule. So when we had approved the board meeting schedule last year, we had selected the usual date in June for the board meeting. But when we looked at the candidate petition filing calendar for independent and new party and then the corresponding objection filing period, in order to call the cases for any objections against independent and new party candidates, we will need to bump the meeting up 1 week. We're statutorily required to hold that first call of the cases within a certain amount of days after the last day of objection filing. So this will ensure that we meet that requirement. So we are requesting that the board meeting be moved now instead to Tuesday, June 9th. We had previously polled members, majority indicated availability that day. So just seeking a formal motion to update the calendar to reflect the new June meeting date.
Thank you, Vern. Do I have a motion?
Can I just make one comment? How far in advance do we schedule these rooms? Do they get the calendar at the very beginning when we decide? Yeah, we schedule them out as soon as we decide on a meeting date. And then the building usually they'll give us a room, but then they will switch us around based on other reservations. So we can request certain rooms, but we don't always get them, even if we reserve them a year out. Okay, so who do we need to talk to make sure that this doesn't happen? Yeah. Because I can't, I mean, I can think of probably 3 or 4 meetings already this year that we've had to deal with this. And it's not like we're doing unimportant work. So whomever, I'm happy to pick up the phone, whomever we need to talk to make sure that this doesn't happen. If we're asking for a meeting space a year in advance, you would think we would get priority and they would work around us. That's all I'm gonna say. I'm sorry I'm being crabby.
No, agree. It's distracting. It's been distracting all meeting, like, I agree.
I mean, we've had a lot of conversations, Marty and I, especially with building management about it and saying that often we are requesting meetings for state government business, not other purposes, yes, and so we would hope we would get the priority, but to date, that has not necessarily been the case. However, opening the meeting without you even mentioning it, I already was going to go to management to say that it was incredibly hard for us to hear. Well, I don't think it's unfair to say that you have the support of the board behind you as to how annoying and how disruptive that is. And that's probably been like 10 octaves above one of the last ones, and the last one was bad. So, sorry.
It's just sort of, I know today in Chicago, we don't have right now members of the public, but like, how does it feel for those who are coming to our meetings? Like, it's distracting for us as members to conduct business, but I also think it's highly disrespectful for those who have previous, right?
Agreed. Thank you, guys.
Thank you.
Bernadette?
So I make a motion to accept the revised meeting schedule.
Is there a second?
Second.
It's been moved by member McCrory, seconded by member Brett to approve the new meeting schedule. Amy, roll call?
Ms. Malacroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Bernadette?
All right. Next is a legislative update. Keep it kind of brief, considering how much is actually going on, but the deadline for bill introduction was February 6th. The legislative report that is contained in the packet lists election-related bills to date. Obviously, we'll continue to monitor to see if new language is introduced into other bills that would have any impact. Again, just a reminder that typically anything election related at the end of session is rolled into an elections omnibus bill. So we can continue to track and monitor anything that we think will have a significant impact. We will bring most immediately to the attention of the legislative subcommittee. Do you think we intend to touch base relatively soon on some of the bills that are drawing our attention? But for now, we're continuing to monitor, responding to any General Assembly staff inquiries about pending legislation, whether it's our agenda or another bill. ISLs, you have a copy of those. Those are essentially our narratives that help to explain our budget request. Provided all the members with a copy. Those are filed, so they were filed as of yesterday. We will field any questions related to those prior to our budget hearings. We do have the House appropriation hearing that we had notice of scheduling. That will be at the end of April. We're still waiting to hear when the Senate appropriate hearing will be, but obviously we will be present and provide testimony on the budget request at those hearings. And at this point, that's my general summary of where we are. I see that Brian Pryor is in Springfield. If there's any further information from Brian or any questions from the board, I'm happy to give it over to Brian. He did, I believe, if the budget address has happened by now, it's been a longer meeting, has been monitoring the budget address as well.
Do we have questions, Brian?
I just have one, please.
Member Craig?
Please.
Brian, I'm sorry we didn't get to meet this week. I know you and Rick and I talked via emails and text messages last week. I just wanted to add one thing to your plate, which I hate to do. I talked to Vice Chair Turvin about this, and that's about our hearing officers. Can you look into if there's a way to make them administrative law judges, something like that, so they are protected now from the lawsuits they're going through? Can you just, in your free time, which I know you don't have much of, but can you just add that to our list? Something to protect our hearing officers?
Certainly happy to look into it. I think it's something that we had previously contemplated, so we might have already gotten a head start on that research.
Perfect.
And then just to your point of us not getting to meet, that's something that, again, will be forthcoming. However, I'd like to establish a more regular touch point prior to board meetings in case these types of inquiries come up, and we can dispose of them ahead of board meetings. But then separately, yes, today was the governor's budget address, and to deliver a tiny bit of good news to you all, you guys were included in the comptroller's budget with a small COLA. So the budget process, as you know, is long and drawn out, but at this point, congrats. So.
Any further questions of Brian? I second what Member Gray said about the hearing officers. That's important. Bernadette?
The remaining items of my report are all informational. I just wanted to make one other point about board meeting calendars as I was thinking about them. We will be drafting for the March agenda, the board meeting schedule meetings for the next year. We do intend to include on that any proposed meetings for state officers electoral board as well.
I can't hear you, Bernadette.
So next month, we're going to propose the calendar of meetings for the upcoming fiscal year. We do intend to include in that meeting the state officers electoral board meetings, particularly any special board meetings that might need to occur. It is likely to be an active objection cycle for independent and new party candidates, therefore requiring at least one, more likely two special board meetings to handle those objections. That will likely be in July, which obviously is the summer. So we want to get those dates to you all as soon as we possibly can.
Appreciate that, always. All right, is there any other business? Springfield, okay, comments from the general public? We wore them all down, they're all gone. All right, now I need a motion to go into executive session for the purpose of discussing the appointment, employment, compensation, performance, or dismissal of specific employees pending litigation and the minutes of January 8th executive session meeting pursuant to sections 2C1, 2C11, 2C21, and the Open Meetings Act. Are we clear in the room? We clear.
Second the motion.
Oh, sorry, gotta take a roll call.
Sorry.
Roll call.
Oh, Amy,
It's been moved and seconded. It's been moved by member McCrory, seconded by member Turbin to go into executive session pursuant to my initial statement. Roll calling.
Telegraph,
Yes.
Ms. Price,
Yes.
Mr. Corey,
Yes.
Mr. Brett,
Yes.
Watson,
Yes.